I recently did a search and seizure training for a local police department here in New Mexico, and I got a ton of questions about curtilage in open fields. And what I found was that for a lot of officers, the concept of curtilage versus an open field and what you can do and what you can't do can be a little bit confusing. So in this episode of the podcast, I'm going to break down the landmark decision in United States versus Dunn. I'm going to talk about exactly what curtilage is, and most importantly, what you need to know about it as a police officer right now. What's up, everybody? Welcome back to the channel. I'm attorney Eric Scramlin, and this, of course, is the Tactical In-Service Podcast, a podcast for law enforcement where I break down training topics and case law to help you, the law enforcement community, stay up on the law. Hey, before I get started, if you haven't done so already, I want to ask you to hit the subscribe button, all the notifications, all that good stuff, because this topic I'm talking about today has a lot of pieces to it, and I'm only going to be talking about the basics, breaking down U.S. versus Dunn. In future episodes, I'm going to expand on this and go into some of the exceptions to curtilage, the knock and announce exception, Florida versus Jardines. So make sure you hit the subscribe button so you get notified when the new episodes come out. All right, let's dive into this topic on today's episode, which is curtilage versus open fields. And specifically, I'm going to talk about United States versus Dunn, the case that gives you as an officer 4 factors to look for to figure out if it is curtilage or is it an open field, because it's going to matter which one it is. One's going to have major protections, the same as the house. The other one's not going to have the same level of protection. So you have to be able to differentiate and know what is curtilage and what is an open field. So let's dive into it. All right, first of all, what is curtilage? What is this fancy legal name, curtilage? What does that even mean? I got a lot of questions on that. And I'll tell you, in doing my search and seizure training with some departments, I review reports, body cam videos, and stuff like that, and I notice consistently officers being on private property. Maybe there's an exception that applies, but they're in this curtilage, but they're wandering around in areas they're not supposed to be in because they don't know. They don't understand this concept. So that's what I'm going to talk about today. What is curtilage? Well, curtilage means what the courts have said more or less, the kind of the basic definition is curtilage is the area around the house, that area in which the intimate activity associated with the sanctity of the home and the privacies of life take place. All right, so what does that mean? It means when you have a house. So when I do this training, I'll throw up on the PowerPoint slide, I'll put a picture of a house up there and I'll say, all right, what do you need lawfully to be able to enter inside of the walls of this house? And every officer understands this. The Fourth Amendment, the home is the chief among equals. We understand the high level, the high degree of privacy that is afforded inside of the home. So the answer, of course, is what do you need to lawfully be in a home? You need a warrant, consent, or exigent circumstances. That's it. That's the only way you as a police officer can go into someone's house. Next, throw up a picture of the yard that's around the house. And maybe there's a barbecue in there, picnic table, something like that. And I ask the question, what do you need to be standing in the yard near that barbecue grill, near that picnic table? And this is where the confusion starts to set in, because the answer is it's the same exact protections as the house. The courts have determined that there's an area in your yard on your property that is so intimately connected to the privacy of the home that it gets the exact same protections. That means, yes, you need a warrant, consent, or exigent circumstances to be in the protected curtilage. All right, so that's what curtilage is. Now, if it's not curtilage, in contrast, it's what the courts call an open field. Not necessarily a field with weeds and stuff in it. It's got a legal definition. If it's not curtilage, it's an open field. So in contrast, the courts define an open field as an undeveloped area outside of the curtilage. It's still private property. It's still the homeowner's land, but it doesn't have that same intimate connection to the house that the yard with the barbecue grill and the swing set in the common enclosure fenced-in area of the yard covers. We're talking about the area that may be far away. Maybe you have a 100-acre ranch and you're way on the back 40 of the the property and it's undeveloped and there's cattle out there, that's what the court's talking about as an open field. All right, so if it's curtilage, then you have to have a warrant, consent, or exigent circumstances to be in there. It's got the exact same protections as the home. If it's an open field, the court says you can enter and be on an open field as long as you have a legitimate law enforcement purpose. All right, so what does this mean? Let's talk about United States versus Dunn, the case that gives us 4 factors that you can look at as an officer to determine, is this area curtilage? Is it protected? The same as the house, or is it an open field, and can I enter into that open field without a warrant, without consent, without exigent circumstances, as long as I have a legitimate law enforcement purpose? So United States versus Dunn is the case that talks about curtilage versus open field, reminds us of the very heavy protections that the curtilage gets, and it gives you 4 factors to look at. Now, it's not, as the court says, a automatic, fine-tuned formula. You got to apply some common sense here. When I explain this, I put these pictures up and say, all right, if you're a municipal officer working in a city, 98% or maybe even more of the homes that you're going to visit, it's all going to be curtilage because they're small property lots. They're in a common enclosure. But if you're a sheriff deputy, if you're state police or something like that, and you're visiting more rural properties, I used to live on a 10,000 acre ranch here in New Mexico. That's where you're going to find areas that are going to be considered the open fields. And so you got to apply a little bit of common sense here. But let's go through these factors. Let's talk about United States versus Dunn. Also, for my New Mexico officers out there, you might be thinking, well, nothing applies here in New Mexico. You're talking about U.S. Supreme Court case law. Well, this actually does apply in New Mexico. We do follow this line of reasoning. I forget the case off the top of my head. If I remember, I'll put it in the comments below. As long as U.S. versus Dunn, you should read it. If you're an officer in another state, this is United States Supreme Court case law. But as always, check with your local prosecutors, your city attorneys, to make sure that your state follows this same analysis. Because, as my New Mexico officers know, states are free to interpret the Constitution and give extra rights under their own state constitution. So make sure you check that this applies. But this is general, basic Fourth Amendment search and seizure right here. All right, United States versus Dunn, 480. United States 294, 1987. It's down there. I encourage you to read it. It's a pretty easy read. Real good case that everyone get a good understanding of. All right, so what do we need to know about this thing? Let me talk about the facts of Dunn to put this into context. So more or less, Reader's Digest version here, Dunn owns a ranch. It's like a 100-acre ranch. And through aerial surveillance and through the police, it's 1987, so I don't know if this is probably not a GPS warrant, but they call it electronic beeper, some sort of tracking device they've placed in chemicals that Dunn is buying. Stuff that you need to make meth, is what it sounds like from reading the case. So through this information, they track the chemicals to Dunn's ranch. Police go to Dunn's ranch. It's like a 100-acre ranch, and on this ranch, there is his house. And about 60 yards away from his house is a barn that's not in great shape. It's got a door that's wide open. It's not maintained around the area. And you can actually see inside the barn door if you're standing outside of it. Dunn's house has a fence, a common fence that you would have around a house. That barn is outside of it, 60 yards away. Also on the property are multiple cattle fences, separate enclosures. So police enter the property from the back end. Way in the back, 100 acres, not developed. It's fields. And then they walk up and they get up to that barn. That's 60 yards from the house, outside of that common enclosure. And they can see inside the barn and they can smell the chemicals that make meth and they can see it. And they think they have enough information. So, and this is also important. They don't go into the barn. They stay outside and they look into it and they can see this stuff. They use that, what they see in plain view, as the basis for a search warrant. Then they come back with a search warrant and enter the barn. Of course, they find all the stuff for making meth, and Dunn gets charged. This case goes all the way to the United States Supreme Court. So the Supreme Court had to determine, the issue was it a search under the Fourth Amendment for the officers to enter Dunn's private property through the back part of that field and then look into that barn that had the door wide open? And the court held, no, it was not a search. And it was not protected, and it was lawful. Why? because the court talked about the fact that you have curtilage and then you have open fields. The officers never entered the protected curtilage. Because they didn't enter the protected curtilage, they were in an open field. They had a legitimate law enforcement purpose. They also never entered inside the barn. They used what they could see from the lawful vantage point in the open field to give them probable cause to go get the search warrant. So in United States versus Dunn, the court held this to be lawful because the officers were lawfully in an open field. They were not in the curtilage. Not only that, the court said, we're going to give 4 factors because they had to determine, were the officers 60 yards away from Dunn's home? Were they in the protected curtilage at that point? They listed 4 factors. So here's the 4 factors, that kind of the most important part of the case here. The court says when determining whether or not it's the protected curtilage that you got to have a warrant, consent, or exigent circumstances to be in, the court will look at, number 1, the proximity of the area claimed to be curtilage to the home. So in Dunn, the barn was 60 yards away. So obviously, the further away from the house you get on the property, the more likely it is to become an open field. So proximity matters. The closer you are to the home, the better chance it is that that's going to be considered curtilage. In Dunn, it was 60 yards away, which is not that far, but it was far enough away where like it wasn't in. And here's kind of the next thing. What's the use of the area? Is the area maintained? Is the grass cut? Is there a picnic table? Is there a swing set? Does it look like they're using it as an area that's intimately connected to the house? Or, as in Dunn, is it a unmaintained field with garbage and trash strewn about that's clearly outside of what you can recognize as the yard? So what is the use of the area is number 2. Number 3, and this may be the most, probably the most important one, is what are the steps taken to prevent observation? What steps has the homeowner taken to prevent someone from looking in there? So in Dunn, you had a barn with a missing door that you could see inside of it. They took no steps to prevent observation. Therefore, that's a factor the court will consider whether or not this is a curtilage or open field. If I talk about this with municipal officers, especially in some areas in New Mexico, a lot of elevation change. If you got someone that's got no fence and you're standing on a public sidewalk, is it a search to look into their yard? No, because you're in a lawful public area and you can see into the curtilage. You can't go in there, but you can see in there. You could see something illegal, use that as probable cause to get a search warrant to get you in there. But what if they have a huge fence, 6-7 foot fence up? Can you climb up the fence and look in? No, that's a search now because they've taken steps to prevent your observation. All right, and then the final factor is this area that you're claiming to be open fields or curtilage, is it in a common enclosure? So going back to the PowerPoint here, you look at most houses, especially if it's on a big piece of property, there is a fence that goes around the yard, around the house. That's usually a decorative fence. Where I lived, it was a little cedar fence that went around the house. You can tell it's decorative, it's designed as a common enclosure. Everything that's in that common enclosure, more likely to be curtilage. In Dunn, the barn is outside of the common enclosure, where the officers entered and walked outside of the common enclosure. Sure, there was other fences out there, but what were those fences being used for? They're being used to control cattle movement, barbed wired fences, horse fence, stuff like that. They weren't designed to be that decorative fence around the yard. So when you approach a residence, you got a wall, some common enclosure fence, and it's maintained, you know that's curtilage. You can't be in there unless you have a warrant, consent, or exigent circumstances. But if you have a bigger piece of property and you look at these 4 factors, again, the proximity, how far away from the home is it? The further away, more likely is it an open field. What is it being used for? Is it maintained? Is the grass cut? Is it not maintained? The less maintained it is, the more likely it is to be an open field. What steps are taken by the occupant, by the owner, to prevent observation? Is it in the common enclosure? Those are the 4 factors. Like I mentioned, they're not a be-all, end-all, fine-tuned formula. Even the court admits that. You got to apply some common sense. If you approach a house in the city and you want to go into that yard, that is almost always going to be curtilage, which means you need to have warrant, consent, exigent circumstances to be in there. More rural property out in the country, if you can articulate, it's far away, It's not maintained very well. It's not in a common enclosure. There's no steps taken to prevent observation. You can lawfully be there in that spot without a warrant, without consent, without exigent circumstances, if you have a legitimate law enforcement reason. You can't just randomly go out and trespass on people's property. You have to have a legitimate reason. Like in Dunn, they were tracking, they did aerial surveillance. They had a reason to be there. All right, so I'm up at about the 15-minute mark here, so I think that's all I'm going to cover. Now, I know that you have a lot of questions thinking like, well, we walk up to residents all the time and we do a knock and talk. Isn't there some exceptions to this? Yes, there are some exceptions, and that's why I want you to hit the subscribe button, because in my next episode, I'm going to talk about Florida versus Jardines and what we know as the knock and announce, knock and talk exception to curtilage. This gives you kind of an easement through the curtilage to go to areas where the public is allowed to go, like up the driveway, on the porch, knock on the door. In that next video, I'll talk about what that exception is limited to, because I see officers get in trouble all the time because they go outside the scope of what they're allowed to do in that. So in the next video, I'll talk about that. I hope this helps at least getting started, understand the basics. You have to understand and know what the curtilage is. As a prosecutor, I've seen, and in my current work in training officers, I've seen big cases lost because we're in the curtilage searching for stuff and then finding evidence that gets suppressed. And it's pretty basic stuff. So make sure you understand what curtilage is and understand that you have to have a warrant, consent, or exigent circumstances to be in the curtilage. And I'm going to talk about Florida versus Jardines and the knock and talk exception on the next video. So make sure you hit that subscribe button. Also, really quick, I want to announce, if you're taking some value from this stuff, I offer a full-blown Fourth Amendment search and seizure for any agency out there in the United States that follows Fourth Amendment law. In New Mexico, my New Mexico officers, we know that it's a lot different here, and I cover this and many other topics in my basic search and seizure course. I also have an advanced search and seizure course. One's coming up here at the end of March in Lovington, New Mexico. That's designed specifically for drug task force agents or those that are working narcotics. Information in the description below. Go to my website, check it out, give me a call. Love to come and help you guys out. All right, until next time, I hope this sheds some light on this subject. Hit the subscribe button, and I'll see you on the next video with Florida versus Jardines and breaking down that exception to be in the curtilage. So until next time, remember, every battle is won before it's fought. Stay safe. I'll see you guys all on the next episode.